Car crash cases, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you. Your tough legal questions answered by our experts. The attorneys with Josh Wright from the law firm of Hollis Wright and host David Lamb.
Hello and welcome into the attorneys. Thank you so much for joining us on this Sunday evening. You know, bankruptcy is not anyone's favorite word, but there are times where it's not only a good idea, it's necessary. Tonight we're going to deal with that topic, and we would love to have you be a part of the conversation. You'll see all throughout the next half hour ways that you can get in touch with us. Would love for you to do so. Also a reminder, all throughout the program tonight, the firm of Hollis Wright will have attorneys standing by live right now to take your calls. So take advantage of that opportunity as well. Leading the conversation for us is Carter Clay from the firm of Hollis Wright. Good to see you, sir.
Good to see you, David, and absolutely you hit the nail on the head. Bankruptcy is a legal process that unfortunately people in our society have to avail themselves of all too often. And what happens is that individuals just start accumulating debt. They start incurring debt, and initially they can meet the payment obligations, they can keep up with the debt, but oftentimes a random event, unexpected event occurs in their lives where they have to get medical treatment. And getting medical treatment and the incurred medical bills as a result of that treatment oftentimes kind of puts them over the edge in terms of being able to meet their debt obligations, and they wind up having to file bankruptcy. In fact, that was one of the leading reasons behind the Affordable Care Act, which is the health insurance for the 30 million individuals that were out there who were uninsured. That a lot of those individuals were having to file bankruptcy because they couldn't pay medical bills associated with medical treatment that they had received. I mean, obviously, whether you agree or disagree with other aspects of that particular law, that is the reality of the situation is that people endure events in their lives where they incur significant debt and wind up having to file bankruptcy. So that's what we're going to be talking about here this evening, and we're very fortunate to have a bright young attorney in the Birmingham area with us named Kayla Schoen. And I've known Kayla for quite some time now. She worked at our office throughout law school. She did an exceptional job on various research projects, and we're so glad and proud of you to see that you've got your own firm right now and are obviously practicing in the field of bankruptcy.
That's right, yeah. I'm super happy to be here. Like Carter said, that was my first job in law school.
Oh, wow.
So to be here now is really an honor. I'm excited.
And you still want to be around these guys.
Yes!
So it must not have been that bad.
No, they are wonderful. Yeah,
awesome.
It was really one of my most favorite jobs. Yeah.
That's great.
Well, thank you, Kayla. Well, let's just jump right into it. And what I like to do oftentimes with these types of shows is give some clarification to the viewer of kind of what we're going to be focused on throughout the evening.
Okay.
And as you know, bankruptcies can be available to not only individuals but also businesses and corporations.
That's right.
But our focus here this evening is going to be on bankruptcies for individuals and not businesses. Is that right?
That's right.
And talk to us a little bit about, there are two main types of bankruptcies that individuals can utilize if they find themselves in a financial predicament.
Yeah, that's right. So it's called consumer bankruptcy. You can either file Chapter 7 or Chapter 13. They're different, and you know, there are pros and cons to each. Chapter 7 is often called a straight bankruptcy. It's a liquidation process of liquidating your assets and using that money to pay off your debts, whereas Chapter 13 is more of a reorganization process. You want to keep your home, you want to keep your car, but the payments are too much right now. So you file, the bankruptcy court takes over, and together with your attorney and the bankruptcy judge and the trustee, you develop a plan to make repayments. It usually lasts between 3 and 5 years. So it gives you that time to keep, you know, what you want, but to pay it off in a doable fashion.
Right. And I know we're going to talk about both Chapter 7 and Chapter 13 in great detail here this evening, but just as a matter of background, as lawyers, we talk about chapters and statutes. What are we talking about when we say chapter? What law was enacted that applies to bankruptcies?
So bankruptcy is the bankruptcy code. It's federal law, and there are different chapters in the bankruptcy code for all the different types. And like you said, there are different chapters that apply for businesses versus individuals. So when we say chapter, it's just a chapter in a book, really.
And so if somebody is contemplating filing bankruptcy, they're going to be filing the bankruptcy petition in federal court, not state court or in Jefferson County Circuit Court. That's not where you would go.
Right. Bankruptcy is its own entity, their own bankruptcy judges, so it's totally separate.
We got a question about how to know whether Chapter 7 is the best option or Chapter 13. Can you create a scenario and help us understand, if we're facing bankruptcy, which one, when is 7 the best road to take and when is 13 the best road to take?
So that's a really good question, and it's very individualized. You know, to be honest, I think the rate right now of failures going through Chapter 13 is like 75%. It's a little bit more restrictive, and it's hard because you're stretching it out over 3 to 5 years.
Now, when you say failures, you mean those that apply for Chapter 13 that get turned down?
Well, they don't make it through the process.
Okay.
Chapter 7 is a lot faster. You're usually done in 4 months. So as soon as you file the petition, the ball starts rolling, the trustee starts marshaling your assets, paying off the debts, and your dischargeable debts are gone, so it's a lot quicker.
Yeah, so in Chapter 13, it's basically you're refinancing your debt.
Okay.
And so what happens in Chapter 13 bankruptcy is that they set up payment plans for the individual filing bankruptcy, and you have to meet those payment plans on a monthly basis or a periodic basis, just as if you were paying off a note or a loan for a car. And if you violate the terms of the Chapter 13 bankruptcy, then what happens is if you don't meet those terms, then you can basically get your case dismissed from bankruptcy, and the creditors can then basically go after the debt again, correct?
And you can transfer. So, I mean, it's not uncommon for someone to get into Chapter 13 and to find, for whatever reason, maybe a few years down the road, they have another medical issue that overwhelms them with debt. And so they might want to transition, say, now I think I should do Chapter 7.
Yeah.
Let me ask you this, with respect to the payment terms that are structured in a Chapter 13, are they dollar for dollar on the debt, or typically do they reduce the percentage that you have to pay on a particular item and maybe the creditor only gets 60 or 70 cents on the dollar? How is all that determined?
The trustee determines that, and the bankruptcy judge determines that. After you file your petition, it's going to include a very, very, very detailed list of all of your assets and liabilities, and they put everything together and figure out, really at the end of the day, what's your disposable income, and then what can you realistically pay back over the 3 to 5 year period. So it's really a team effort with you, your attorney, and the guidance of the bankruptcy court.
And is the main advantage of Chapter 13 perhaps over Chapter 7 from the debtor side? Is it that they get to keep their assets, they get to keep their car, they get to keep their house and try and catch up and make these payments?
Right. Yeah, it's for people who really want to keep everything that they have. They just are overwhelmed by what they're having to pay each month. So that's really where they're coming from.
Time for us to take our first break of the evening. So we're going to step aside. As we do so, a reminder how you can contact the show. We'd love to have you be a part. Also, the firm of Hollis Wright, a great educational and informational resource on social media. Search the term Hollis Wright to find them on Facebook. On Twitter, they are at Hollis_Wright. So take advantage of the social media options and opportunities here at Hollis Wright. Stay tuned. More of The Attorneys coming right up.
I'm Josh Wright with the law firm of Hollis Wright, a personal injury law firm. Thank you for watching The Attorneys. Now, we hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple. Provide answers and legal counsel when you need it the most. Your call to the show is free, so if you have questions specific to the show or related to other accident or injury-related topics, you can call, email, or text us. Or you can also follow us on Facebook or Twitter, or simply contact us by going to hollis-wright.com and click on the Contact Us link. We know your time is valuable, so thank you for spending it with us watching The Attorneys.
Welcome back in to the attorneys talking about bankruptcy tonight. Would love to have you be a part of the conversation. Ways to call, text, email, all that there at the bottom of your screen. So take advantage of that and join our conversation. Carter?
Yeah, Kayla, I want to explore Chapter 7 bankruptcy a little bit more, which, as I understand it, as you described it, is total liquidation, which essentially means you provide an accounting of all of the assets that you have in your possession, and literally the bankruptcy court takes possession of those assets. They figure out how to sell off the assets. They liquidate everything. They use the cash then to pay off the debts. Is that essentially what happens?
Right, and I should have mentioned this earlier. One of the bigger distinctions between Chapter 7 and 13 is you have to qualify to do Chapter 7 because it's so fast and it's a liquidation of everything. You're discharging a lot of debt. You have to pass what's called the means test. So some people may not qualify for Chapter 7 and may be forced to do Chapter 13.
And what is the means test? Is that what does that mean exactly, and what factors go into that?
It's a kind of a complicated process. It's probably more confusing to talk about it than to do it, but the basis is you're taking your income, your assets, your liabilities, you're calculating everything together to come up with, like I said, what's left after everything's paid off. And if you have enough, you may have to go through Chapter 13. It's usually close to what the median salary is for your state, but there's a lot of websites that you can put in the numbers yourself and it'll tell you for free whether or not you would qualify.
Now, is the purpose of that means test to prevent people from taking advantage of the total liquidation route when they actually have the ability to pay off the debt?
Right. Okay. It's one thing if you say, I have $300,000 in debt, but if you make $3 million, it's a lot of debt, but you can probably pay it off. Right. So yeah, it's to avoid somewhat of an abuse of the process.
A question here about the cost of bankruptcy. How much does it cost to do so? Kind of a general question, but as best you can, kind of help folks and give them an idea as to what sort of costs we're talking to, the expenses of going through bankruptcy.
Right, so that is a very common question. People think, I need to go through bankruptcy. How am I going to afford an attorney?
Can't afford it, yeah.
So it's based on the complexity of the case for Chapter 7. Usually, most firms will take a small deposit just to go ahead and get started with the filing fees and to get things rolling, and then set up a payment plan for the client to pay it off. Obviously, Chapter 13 is a little bit more expensive because you're helping the client over a 3 to 5 year period.
Right.
So I would say the average is between $1,500 to $3,500 total.
Right.
But by doing that, you may be saving yourself $60,000 in debt. So it's a good investment, but I understand people's concerns.
Does it always require a court appearance, bankruptcy?
You do have to go to court once. After the petition is filed, in 30 days, you have to go to court. It's very informal. It's not like Law and Order or anything scary.
It's not an interrogation.
You just go and swear to the judge that everything you've put in the petition is true. You haven't, transferred anything out or, hidden anything. So it's probably a 5-minute process.
If you file for bankruptcy, whether it be Chapter 7 or Chapter 13, I'm assuming that you have to serve all of the known creditors with your bankruptcy petition. And once you get service, can those creditors continue to try and collect on that debt, or does the bankruptcy court step in and protect them from further collection during the proceedings?
Right, so as soon as you file your petition in bankruptcy court, the clerk's office actually takes care of that, and they send notices to all the creditors that are listed on your petition. And once that happens, we call this the automatic stay. Creditors can no longer contact you call, harass you. If your wages are being garnished, that has to stop. If a lawsuit's pending against you, that has to stop.
Much to our chagrin.
Right, yes, right. I've seen it happen more often with business disputes, but yeah, that's really nice. That gives people the opportunity to hit the reset button and not have all the stress of the creditors knocking on their door.
Yeah, and David, usually what happens from our practice's perspective is that if we have an ongoing lawsuit or we file a lawsuit against an individual defendant who has filed bankruptcy or is in bankruptcy, once we find out, the automatic stay applies to our continued efforts to prosecute that, say, automobile accident or that civil liability claim. But oftentimes what happens is that we can get immediate relief from the bankruptcy court because most of the time we are going after insurance money and not that individual's assets. So what we do is we would file a motion to release us from the stay for purposes of only going after insurance proceeds. But that does happen from time to time.
Yeah, another question that we have here that I'm sure you get quite a bit is, how does bankruptcy affect credit?
So it will go on your credit report for 10 years, and that sounds like a long time. And I know that people are pretty diligent about keeping a good credit score for a lot of reasons. But after a certain amount of time, it matters less and less. You have to keep in mind that people understand at least you're being proactive about taking care of your financial situation, and you can rebuild your credit.
Well, what happens at the end of the Chapter 7 liquidation proceedings? How does that particular bankruptcy end up, and how does the debtor get relief? I mean, is it totally discharged once they liquidate and sell off everything? Yeah,
pretty much everything is discharged that can be. There are some debts that are not dischargeable, so certain things, anything that is related to child support, alimony, anything you've agreed to in a divorce decree, the bankruptcy judge is going to honor that.
Student loans?
Student loans, unfortunately, and I'm there. I'll be paying them off forever. So
if there's any viewer out there that has a lot of student loans and they're contemplating bankruptcy, Chapter 7, they may want to reconsider.
I'm sorry, you can't. Yeah, not yet. Maybe one day. But yeah, and other things, taxes, and any legal penalties or fines, things like that, you can't discharge those.
Yeah, from our perspective, if we get a judgment for, say, punitive damages, somebody's drunk driving, they're found liable by a jury and punitive damages is awarded, those types of damage awards are oftentimes not dischargeable, I think, in bankruptcy.
That's right.
Yeah. Question here, does my spouse have to file with me?
It's a good question. No, they don't, unless you've taken on a debt together. You can absolutely file just as an individual if the debts are just yours.
Let me ask you, this may be a little complicated, but does the bankruptcy try and make sure that people are not trying to take advantage of the system? Because I could see scenarios where you had a primary debt in, say, the husband's name, everything else was jointly held. They file for bankruptcy on that one particular debt, but not on anything else, and it seems like they might be able to kind of game the system a little bit. Is that something that the bankruptcy court will evaluate?
Definitely. The trustee is going to look very carefully at your petition. That's part of the reason you come in and swear under oath that everything is truthful, because if you try to transfer anything out to sort of hide it, maybe you ask your brother, hey, take this, put it in your name for a little while. That's what we call a fraudulent conveyance, and you can get in a lot of trouble for that.
Or they may try and bankrupt one debt and then reallocate their resources to the other debt.
Right.
So.
Yeah. Time for us to take our second and final break of the evening. As we do so, again, a reminder of how you can get in touch with us and join this conversation. Would love to have you join us. A few minutes remaining, so the clock is ticking. If you want to take advantage of those live attorneys standing by, do so quick, because almost out of time. Stay tuned. More of the attorneys coming right up.
I'm Tyler Vale with the law firm of Hollis Wright. In court, attorneys are not allowed to tell juries certain things. For example, we cannot talk about a defendant's net worth, meaning the defendant's ability, resources, or insurance to pay a verdict. In this week's Legal 411, we're answering the question, Why can't lawyers talk about a defendant's net worth to a jury? Rule 403 of the Alabama Rules of Evidence states, although relevant, evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence. Long-standing Alabama cases have held that the net worth of a defendant falls under this catch-all rule. The reasoning behind the rule is that if a jury knows a defendant is wealthy, then the jury might award more money to the plaintiff. And this goes one step further. If an attorney makes any remarks that suggest the defendant is responsible because he is rich and the plaintiff is poor, that can be grounds for a new trial. If you're ever on a jury, the reality in our state is this. In almost every lawsuit that goes to trial, the attorneys representing both the plaintiff and the defendant have already looked at whether there is sufficient insurance coverage or assets to satisfy a verdict. The reality is this: the parties would not pursue a civil lawsuit if damages could not be paid after a jury returns a verdict. So even though lawyers cannot mention the net worth of a defendant during a trial, there could still be resources available to pay a verdict in court. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. Remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you.
Not a pretty picture. Welcome back into the attorneys. The final segment right here. Those live attorneys standing by. So if you want to speak with them, take advantage of that right now. A question I want to get to here, if I can read this small print right here. What about using a credit counselor as opposed to filing bankruptcy? Is that a better option?
In my professional opinion, it's not.
Okay.
I know you're bombarded with commercials all the time about credit consolidation and counselors. You have to be careful, do your research on that company. There's a lot that have taken abuse, taken advantage of people who are already in a really difficult situation. So I would say, obviously, hire an attorney over the counselor. They're not all bad, but be careful.
Do you fill that role at all in your practice in terms of counseling either against or in favor of bankruptcy? I mean, I know that's got to be something that you consider, but do you find that when people come to you, are they pretty much well versed enough in the field of bankruptcy to know they're likely going to have to file bankruptcy? Kind of what is your role in that regard?
I think when they come in, really, they're just experiencing overwhelming debt and they want to know how it works, what are the options, things we've talked about. And I do like to counsel people because you don't always have to file bankruptcy at all. For instance, if you had an American Express credit card debt of $20,000, you may be able to settle with American Express for a lot of times half. You'd have to pay it faster, but if that's doable for you, that may be an option versus filing. So there's some ways to get creative with handling all of your finances.
So some of these creditors outside of bankruptcy may be willing to restructure the debt with you and work with you because obviously they want to get paid on the debt. It doesn't do them any good for you to get discharged in Chapter 7. So I would think that a lot of these creditors would probably work on a restructuring basis as well.
Yeah, they will.
Now, how about with respect to employment? Can bankruptcy affect your employment at all in terms of your employer terminating the relationship?
No, it's discrimination just like any other type of discrimination. Federal law prohibits an employer from firing you or anything because you filed through bankruptcy.
Have you seen that from time to time?
People are worried about it. I think it still has a stigma to it. People sort of feel like, I failed, I made a mistake, and that's really just not true. It was developed to help you reset. That's the whole purpose, but people are worried, yeah.
Time probably for just one more question. Can I file for bankruptcy multiple times?
You can, but you'll have to wait. So with Chapter 7, you have to wait 8 years from the date of your first filing to file again. If it's Chapter 13, you can do it in 2 years. Well, since Chapter 13, the process usually spans 3 to 5 years. Most of the time, you could, for instance, file for Chapter 13 the day after your debts are discharged.
What an optimistic inquiry.
Yeah,
Can I file multiple times?
They're ready. About 3.5 minutes remaining, but I want to just ask you, a lot of times people come to you when they really are in a tough spot. Do you enjoy the role of kind of helping them, letting them know that, life's not over, it's going to be okay, and there is a way out, that things oftentimes are not as bad as they seem?
Yeah, I really do. I started my practice knowing that I really wanted to do something to help people. Right. And bankruptcy is a really, I know it's strange, but it is fulfilling to help people who know I'm in dire straits, what am I going to do? And I say, let's get a plan together. Right. I'm going to be beside you the whole time. Yeah.
And there are a lot of reasons why people are stressed out about life and a lot of different aspects of life. But I would think accumulation of debt and financial issues is a leading cause of stress for many people.
Yeah, we're just about out of time, but I want to give both of you an opportunity for just a final thought, something you want to leave with our viewers tonight, and why don't you go first?
I just want to say I'm really grateful to be here. It's been a fun time, and if you're thinking about bankruptcy, there's a lot of information on the internet that you can kind of get a general view of what it's like, and then feel free to call me or any other attorney and talk about your options.
Yeah, and I would just say, if you're in a situation where you have to file bankruptcy, don't try and take advantage of the system. I mean, it's there for you to get a fresh start, but it's critically important to the system and to individuals to disclose all of their assets, to disclose what they have and what the value of those items are. Because in my practice, what I've seen from time to time is, and a lot of people don't realize this, a personal injury lawsuit or claim is considered an asset by the bankruptcy court. So if you've got an automobile accident claim or an automobile accident lawsuit, you have to disclose that as an asset to the bankruptcy court. And if you fail to do so and you get discharged in a Chapter 7 proceeding, and the attorney in the automobile accident case finds out, your case can get dismissed from court because of what they say you've committed a fraud on the bankruptcy court.
Right, yeah, an important note to end on. Thanks to both of you, for the time. I appreciate you being with us, and as always, we really appreciate you joining us each and every Sunday night. Thanks so much. As we wrap things up, here's how you can get in touch with the firm of Hollis Wright. Thanks again for joining us. We'll see you next time right here on The Attorneys.
Thanks for watching The Attorneys, sponsored by Hollis Wright.